Good morning and welcome to the North Carolina Court of Appeals. My name is John Tyson. The panel today, to my right is Judge Valerie Zachary. To my left is Judge Julie Flood. Our courtroom clerk is Ms. Catherine Bryant, and our court marshal is Tom Salou. We have one case on the docket today, State versus Spry. Are there any preliminary matters to come before the court? Okay. Hearing none, we will hear from the appellant. Good morning.
Your Honor, I'd like to reserve 10 minutes for rebuttal.
Okay. Yeah.
May it please the court, my name is Heidi Reiner. I'm here from the Office of the Appellate Defender representing Nicholas Spry. I'm here today to talk to the court about why the lower court erred when it summarily denied Mr. Spry's MAR, and to ask this court to remand his case for a hearing at which he can present evidence in support of his ineffective assistance of counsel claim. My plan today is to focus on the post-release supervision aspect of this case, which I believe is the most straightforward, but I'm happy to answer any questions the panel has, of course, about any issues in the brief.
There's been a number of years since your client was convicted.
It has.
And I think your client has completed his active sentence.
He has.
Has he also completed his post-release supervision?
He has.
So other than are you challenging any of the convictions that resulted in the active sentences, which would be the robbery?
He's asking for withdrawal of the plea altogether. So yes, removal of all three convictions, the kidnapping, the attempted kidnapping, and the common law robbery. He's asking in this case to withdraw that plea completely.
Okay. So even though he's completed his active sentence, is there anything in the record where you're challenging the robbery conviction?
Well, he's saying that he entered this plea unknowingly. My understanding is that it's a package deal. It was a judgment that was combined. They were all together, and he was obviously sentenced for the highest, which was the second-degree kidnapping, but the robbery was included with that. Okay,
let's talk about the satellite-based monitoring requirement. My understanding from the arguments that you're asserting is that, one, the consequences of the guilty plea to the attempted kidnapping and the kidnapping. One was, since it involved a minor, it triggered a requirement for a 5-year post-release supervision, and it also required him to register as a sex offender, correct?
That's right.
So, but that was from the kidnapping, not from the robbery, correct?
That's correct.
So he has completed. Why is the case not moot if he's already completed his post-release supervision?
Well, I think because he's asking for withdrawal of the plea completely, it's a remedy that's going to go to things like prior record level. It's going to go to any future federal sentencing or points. I don't think it's moot, and he's still on the registry. So these issues are still out there.
So, presuming we would agree with you and send it back, your client's still going to be under indictment for the original charges.
That's right.
So explain to me how that would work.
How it would work in what way? I'm sorry.
Well, he's back before the Superior Court with a robbery indictment and 2 indictments for kidnapping a minor.
Right. So what he's asking for is a chance to either decide, work out a new plea, which, as you I'm sure saw in the affidavit attached to this MAR, the trial attorney said that in cases like this, where there's actually no sexual nature to the crime, and a client is worried about registration, he has in the past been able to work out different pleas to different charges. So maybe Mr. Spry chooses to work out a plea where he spends a little more active time and doesn't take the registration, something like that. But Mr. Spry is fully aware that that's where he's going to be. I think the real concern is I think the other concerning fact in this case is that checkbox on the judgment in this case that triggered that 60-month PRS and that triggered the registration was done without Mr. Spry's knowledge, right? So he did not have any knowledge that this was happening. He didn't know that he was subject to these enhancements until just before he was released.
Am I correct that the indictments for the kidnapping and attempted kidnapping both noted that the victim in both cases was a minor, the indictment?
The indictments absolutely did.
So you're not claiming lack of notice?
No lack of notice, just ineffective assistance of counsel for his attorney not recognizing that kidnapping of a minor was going to trigger those enhancements.
Do you also agree that if we would agree with you to vacate the plea, that that would moot the IAC claim?
That would, I assume that would be done by acknowledging the IAC claim and then presuming that when it went back, counsel would know at this point that kidnapping of a minor does, in fact, trigger these requirements, and work with Mr. Spry to find a plea or go to trial.
Is our standard of review on the registration requirement and the post-release supervision requirement different?
I think the standard of review is the standard MAR review standard, whether there are facts to support the claim and if those, or allegations in the pleadings, and if those pleadings, if believed, were to support relief.
That's not what I mean.
Okay.
I think that the essential difference is if we decide whether or not the registration and the post-release supervision was a direct or collateral consequence to the plea. Do you agree with that?
That you will decide that, yes.
That is the ultimate issue.
Yes.
Do we have? Go ahead.
Excuse me. So are you then conceding that Padilla doesn't really apply to this case?
I think that Padilla is not retroactive. I agree with that, absolutely. I do think that Padilla is informative still. I think that it says that the distinction between direct and collateral is a lot less defined than we think. And I think under North Carolina law, the definition is whether it has a definite, immediate, and largely automatic effect on the range of defendant's punishment. I do think that that's what you have to look for with regard to the PRS and also with regard to the registration. And I think deciding that either one of those fits that definition is sufficient in this case.
Well, how do you respond to the contention that a direct consequence of a plea must be a criminal punishment?
I think that the case that the state cites for that has not been adopted by our state courts at all. I think that the definition that our state courts have used is that a definite, immediate, and largely automatic effect on the range of a defendant's punishment is the standard that has been adopted by our appellate courts. And I think that PRS certainly fits within that because PRS is built into North Carolina statutes. When you look at the sentencing chart, Mr. Spry's sentence, for example, is 25 months to 39 months. That 9 months of PRS is accounted for in that 39 months. It is on the face of it. The thing that isn't built in is that when there is a conviction that triggers this enhanced 60 months, that's not on the face of the sentencing chart, but it is absolutely exposure that that person is going to face. And so in this case, Mr. Spry thought he was pleading to a maximum exposure of 39 months, but in fact, once he finished that 39 months, he still had 51 months of exposure left after the fact.
Criminal or civil exposure?
It's criminal exposure. He's under imprisonment. He's under community supervision, and the definition of PRS under Section 15A 1368A1 is the time for which a sentenced prisoner is released from prison before the termination of his maximum prison term. So that PRS is included in the prison term. That's a term of imprisonment, because of course you might start your PRS outside of the community, but the second that's revoked, you're back in custody. That's still part of your prison term, which this court has said in both Corkum and Sparks, that when that's reactivated, that part of it is the PRS term, regardless of whether it's reactivated or it's part of the original sentence. And I would also point this court to United States versus Stone, which is a Western District of North Carolina case. Of course, it's not binding on this court, but I do think it's the most thorough discussion of why PRS is an inherent part of North Carolina sentences. In that case, the defendant was challenging a possession of a firearm charge and said he didn't have any qualifying prior convictions because his underlying felony was 5 to 15 months, and he was saying, look, I never faced over a year because of the top of that range is 9 months of PRS. And the Western District said, no, absolutely not. Post-release supervision is an inherent part of the term of imprisonment in North Carolina. They went through a number of factors. I'll just list a few of them. First of all was the legislative history of the JRA, saying that legislation was meant to increase maximums and increase punishment, but also decrease prison populations by building in that PRS period. But then they also talked about how the sentences, the sentencing chart, like I mentioned in the statute book, and on the face of the judgments, builds in that to the sentence and doesn't make any distinction about the last 9 months of the sentence being initially served on post-release or being incarceration. It's all called imprisonment on the face of the judgment. And then finally, the other thing that they talked about was that, again, back to the statutory definition, was Section 15A, 1368, where the definition makes clear that a defendant has not served out his maximum prison term when he is placed on post-release, and since he is released before his maximum term of imprisonment is terminated, the post-release supervision period is seen as completion of that term of imprisonment.
Let's return back to the registration, which seems to be the residual impact on your client.
Which is my next question as well.
Two questions. Do we have good precedent in North Carolina that, one, that registration is collateral, not direct, and that it is a non-punitive, that basically that the courts have held that registration is not a punitive condition?
My answers to those would be no and yes, respectively. So, yes, registration is non-punitive, is what our courts have said. Again, as I told Judge Zachary just a minute ago, I don't think that that matters to the analysis in this case, but I do think that there's no precedent on the question of whether it's a direct or collateral consequence yet from our courts. SBM has been addressed in State versus Bear,
Right.
but I do think that registration is fundamentally different from SBM because SBM requires a hearing, it may be a bring-back hearing, it requires specific factual findings like, does this person require the highest level of supervision? It's usually a whole proceeding unto itself after sentencing takes place or sometimes many, many years down the line, whereas registration, there's a statutory list of crimes. If you have one of those crimes, check the box, that's it.
Yeah, well, that's what I'm saying. Would you agree that registration is much less intrusive than SBM, than satellite-based monitoring, on the restrictions and cost and degree of freedom?
I think that may be true physically because you're not wearing an ankle monitor, but
Not paying for it either.
right. But I would say that I don't think that I can agree to that as a person who's not lived under registration. Mr. Spry, as the record demonstrates, is largely unhoused, homeless because of his status on the registration because it's so difficult to find a place to live that's not within 1,000 feet of a school or a daycare or whatever the restrictions may be. I would be hesitant to ever say that it's not very restrictive.
So is it your contention then that an automatically imposed condition is not collateral?
I think when it meets this definition that it's direct, automatic, definite, immediate like this, yes. I think that would be my position, especially in this case where there are, I mean, it has to be on the range of a defendant's punishment, right? But I do think that even though we've said it's not punitive in itself, it does have this intense effect on people's lives, and I think that's where Padilla comes in. Yes, it's not retroactive. Yes, it's not binding, but we do have to think about what the professional norms were at the time, which in the appendix to the original brief, I've cited some standards that showed that counsel should have been warning people about registration. It does have a very, even though it's not a punishment, it's very punitive in nature. And that line, I think, is not as clear as it maybe once was.
So the next question is prejudice to your client.
Yes.
Even if we were to agree with you that the post-release supervision was direct and he should have been informed, if we agree with you on that, but we also hold that the the registration requirement is collateral, where's your prejudice?
I think the prejudice is that he entered an invalid plea from the outset, and he's asking to have that withdrawn. He didn't know about that.
Let me ask you this. If he goes back and he's charged and he's convicted or pleads to, we're right back where we are we not?
If he pleads to the exact same thing.
Or is convicted.
Or is convicted, we're not in the same place if he enters that plea knowingly, or if he goes to trial knowing that these are the likely risks, right? The underlying problem here is that his attorney did not tell him about this extreme exposure to post-release supervision that he would be facing, that he would be branded as a sex offender despite never having a crime of any sexual nature then at the time as a 21-year-old or since. So, his outcome may be the same, but I don't think we're in the same place legally or in terms of a just world.
In terms of the consequences to your client, there's a pending motion before the court on a petition for writ of cert. Are you counsel on that as well?
I am counsel on at least one of those. I don't know which one you're referring to.
The one that was, okay, is one that is pending before the court right now.
I don't know that I'm counsel on the one before the court right now, no. I know that I have one other MAR for review for a PWC.
And is it based upon a subsequent charge for failure to register?
Yes.
Okay. So there was one that was filed in 2023.
Okay.
Let's see if it lists, though he was pro se on that one. But you are counsel on the other one.
Without the file numbers, I don't know for sure. I'm
Okay.
sorry. I can follow up with you if you'd like.
All right.
And let you know what I'm counsel on.
So going to the IAC, we talked about Padilla as the case where was that the deportation case?
That's right.
Where the consequences of the guilty plea would be a deportation.
Right.
Didn't the Supreme Court have a later case following Padilla that kind of backed away from that?
I don't think that they've backed away from Padilla.
Give me a moment, I'll locate it.
If I might just say about Padilla, I think one of the...
It's Chadez,
Okay.
Chaidez versus United States. It's a 2023 case from the Supreme Court, U.S. Supreme Court.
Okay.
Did it not retract some of the, or add some nuances to Padilla?
It may have. I don't know exactly what you're referring to. Sorry.
You may want to, if you want to present it as a memorandum of additional authority, you can certainly do that.
Okay. Thank you. And I will say about Padilla and also this court's decision in Saldana, I think that's a little bit different given the non-automatic nature of immigration consequences. Yes, a person's status may become immediately deportable, but as we all know, like whether a person is deported or not depends on a lot of factors and doesn't necessarily happen. Whereas PRS and registration are automatic. They happen, they're direct consequences in this context. And I think, I'll just say about prejudice again, Judge Tyson, you asked some questions about that, but I guess the measure, the standard there is that the defendant must show that there's a reasonable probability that but for the errors, he would have not pleaded guilty. I think this was sufficiently alleged in the MAR and in Mr. Spry's affidavit, And as I mentioned, the trial attorney talked about different ways that this has worked out in the past for him. And I do think that the state has conceded that Mr. Spry pled this sufficiently, but then went on to argue that there were made factual arguments about what it calls contemporaneous evidence that Mr. Spry would have in fact taken this plea. Those are exactly the type of factual arguments that are meant for an MAR hearing. And so given that, under Section 15A, 1420, I would ask for a remand for a hearing on this question.
Let me ask you this. We have collateral consequences to guilty pleas or convictions, three strikes laws, habitual felon laws. Have you found cases where the consequence of being convicted or pleading guilty to multiple felonies does have later consequences, and whether or not a defendant should be told about those consequences as well?
Well, I guess in the context of habitual felon, I would point this court to State versus McNeil. In that case, they're talking about when you plead to that status of habitual felon, there are these enhancements to your sentence. Obviously, your sentence increases, and of course, you have to be advised of that increased max. I think
But that's a separate indictment.
it is a separate indictment.
So that's notice in and of itself, and it lists the underlying felonies that the state's relying on, correct?
It does list those, but here, I mean, we have the problem of this judgment being entered after the fact, right? It seems like everyone in the courtroom didn't really know that this was going to be a triggering conviction. Mr. Spry wasn't told. His attorney apparently didn't know. It doesn't seem like the court said anything about it. It doesn't seem like the prosecutor said anything about it. It's really only after combined records sends a letter 2 weeks after the judgment is entered to the clerk of court and says, hey, what actually is going on here? Was this kidnapping of a minor? And they, I guess, take it back to the court and get the box checked. But Mr. Spry doesn't know about that. His attorney doesn't know about that. And that's a pretty significant factual finding that's made on that judgment without notice and without, I mean, we don't really have a record of exactly what happened, which I think is why a hearing is necessary.
I have three quick questions, and I will give you your full time on if you need it.
Sure, thank you.
Number one, did you ever get a copy of the transcript of the plea in terms of the from the court?
We have not, and I guess I would hope that would happen with a hearing.
But there is a transcript, there's a written transcript of the plea in the record, correct?
A written transcript, yes.
Okay, that was one. On the, did you or your client get notice of the letter from Central Records?
Yes, it's at page 15 of the record, I believe.
Did you get notice before the correction to the judgment was made?
Oh, I wasn't counsel then, but I don't believe anyone did, no.
Okay, and then that's the third question. Was your client called back into court when the record was corrected?
No.
Okay, thank you. Anything?
No.
Anything? We'll reserve 10 minutes for her if she needs it. Thank you. Mr. Hayes?
Good morning, Your Honors.
Good morning.
May it please the Court. My name is Caden Hayes. I'm with the North Carolina Department of Justice, and I'm representing the state in this matter. Your Honors, there were a number of issues presented to the trial court below in an effort to undo a nearly 20-year-old plea, two of which were the subject of the most briefing, and I'm going to address both of those in turn. I do want to hit on a couple quick points that were brought up in my colleague's argument. Most notably, Your Honor, the Supreme Court's decision in Chavez was a understanding or was a finding that Padilla was not retroactively applicable. This court had already come to that conclusion in another matter. In so doing, Chavez recognized that sex offense registration or registration schemes generally are, quote, commonly considered collateral consequences of guilty pleas. So with that kind of up in the air, there are a number of procedural matters that were addressed in the briefing that I think dispose of this case. We talk about registration first. We have this Jacoby discussion where this court found that sex offense registration is not a criminal punishment, which I know my colleague is disputing whether criminal punishment is a part of the direct collateral discussion, and I will certainly talk about that in a second. But the other thing is when it comes to PRS, that was not properly raised in his first MAR. He was citing Blakely principles, which are unrelated to ineffective assistance of counsel. And though he seemingly raised this issue in his subsequent MARs, those attempts to raise that issue were procedurally barred as being second or successive without satisfying the relevant good cause and prejudice analysis required under the statute. So with those matters out of the way, I want to turn more briefly or more robustly to the discussion, which is ineffective assistance of counsel.
Well, before you go there, let's deal with the underlying substantive issue, if you don't mind.
Certainly, Your Honor.
Because I think if we do agree to to send it back, the IAC issue goes away. Would you agree with that?
I think there are still some discussions that can be had. I think prejudice is still somewhat of an open question, though the state, to be clear, contends that there is no prejudice on the record. But simply remanding for a hearing would, I think, would make more discussion rather than, I guess, make it go away.
Is it typical that if a judgment's going to be changed, that a defendant would not have notice and opportunity to be present for that?
Well, when it comes to clerical matters, Your Honor, no, I don't. I think it is typical that clerical matters are corrected to the extent that we're now claiming that this was not a clerical error and it was more of a judicial finding. I think one that wasn't raised below, that certainly wasn't discussed here. I also think it's I think it at bottom is an incorrect assertion in that, as you pointed out, Judge Tyson, the indictments did list the victims as minors, and that's the only box that was checked, was that the victims were minors. We saw that in the indictment. We saw the written guilty plea. I don't think there was any sort of issues of kind of fact wherein maybe they weren't minors. I think that was well established, which brings us into, I think, in my mind, a clerical error type thing.
Well, then, if the state's going to take that position, that he was on notice and that it was right there in the indictments, but counsel did not tell him that the consequence of the plea would be 5 years instead of 9 months, and also lifetime. Is it lifetime registration?
No, Your Honor, it's only 30 years.
Okay, and I think the record indicates that after 10 years, he did try to seek to have to be relieved with that and was denied. Is that correct?
That's correct, Your Honor.
And I'm also correct that most of the offenses subsequent to that relate to his failure to register, correct?
That's correct, Your Honor.
So I'm trying to, can you have it both ways? Can you say, oh, he had notice, it was in the indictment, the box was just a clerical, but his attorney didn't tell him? I mean, it seems to me like that would trigger a deeper analysis if we accept your reasoning, that would trigger a full IAC analysis at that point. Are you sure you want to go there?
Well, I think, Your Honor, there's a difference between checking the box and the discussion about registration. The box only said that the offense involved a minor. It didn't say you were going to be subject to registration. That registration requirement was going to be there regardless. I think that's a separate discussion than whether he was going to be subject to registration, which he is, to be clear, based on those convictions. But this gets to whether his attorney had an affirmative obligation to inform him of these registration requirements, which would require it to be a direct consequence. And of course, there's also then the second step of IAC, which is prejudice, which I'll get to in a second. Does
the district attorney have the right to waive in a plea bargain, to either waive the 5 years or the registration as part of a plea?
I'm unaware of any right of that nature, Your Honor. I think it applies quickly based off of the underlying conviction.
So you do not think that a waiver of those two conditions was within the power of the plea that the state would accept? I
am setting aside kind of the policy concerns of what the local district attorney would feel is appropriate in that matter. I am unaware of any legal ability to kind of alter the registration requirements back in 2007 when the plea was. I'm certainly happy to look into that and file a memorandum of additional authority on that matter, but off the top of my head, I'm unaware. Okay. But still, we get to this discussion of direct versus collateral. Direct is a narrow class of consequences because it has this potential to undo pleas decades later. Our Supreme Court and this Court have zealously and carefully limited it to certain very specific instances that are consequences which are immediate, which are definite, which are largely automatic, and affect the range of the criminal's punishment. That fourth part in particular answers the questions before this court today, should we kind of set aside these procedural concerns for a moment. Criminal punishment is an integral part of the direct collateral analysis. There are a multitude of things that happen automatically when someone pleads guilty to an offense. Those who get, for example, DUIs can lose their commercial driver's license. Those who become felons lose their abilities to have firearms. But there's been no finding by this court or our Supreme Court that those are direct consequences, or at least I'm unaware of any. And that goes down to the fact that it's not a criminal punishment. This is the crucial part. Now, to be clear, the state did bifurcate the criminal punishment discussion into something that is, one, outside the court's purview, of which PRS certainly is, and then two, this kind of more, is it a penal idea? Is it supposed to be punitive? To be clear, that first prong has not been adopted by this court. Though we have adopted the Fourth Circuit's, that specific definition of it has not occurred yet. I only included it in the briefing to kind of raise it before this court for consideration. But even setting that aside, we still have Sokobi, which says this is not a criminal punishment. Thus, it cannot be a direct consequence that an attorney has an affirmative obligation to inform his or her client about. And this is not necessarily a legally controversial finding. As the Mississippi Supreme Court observed in Magyar, virtually every other jurisdiction that has considered this matter has concluded it is a collateral consequence. The Supreme Court in Chavez concluded similarly. The Supreme Court in Smith v. Doe concluded similarly when reviewing the Alaska set of registration requirements. So at bottom, it's not a criminal punishment, and thus it cannot be a direct consequence. Full stop. And that ends that IAC claim before we discuss hearing, prejudice, or anything else.
Does the state at least agree that we have not decided whether post-release supervision is direct or collateral?
I'm unaware of any cases on that, Your Honor.
And would the state also agree that New York, New Jersey, Kansas, and the majority of jurisdictions that have reviewed that issue has decided that post-release supervision is punishment and therefore is a direct and not a collateral consequence?
I disagree with the majority of jurisdictions' point. I think New York, New Jersey, and Kansas employ very different systems than North Carolina's. When we're talking about what is a criminal punishment, what is a direct consequence, there's a number of different state-to-state analysis. New Jersey, for example, uses a different definition of direct consequences. New York has a different scheme, as does New Jersey, in terms of how they operate their PRS, how intrusive it is, when it occurs. And I think this gets point to whether it is a criminal punishment of. Do
you agree that at least it's a sentence? It is part of the sentence.
PRS in North Carolina?
Yes.
No, Your Honor, I don't agree with that. The PRS, though it pauses a defendant's sentence, does not make it a sentence by itself. Its purpose is remedial. It's to integrate somebody back into society after spending a period of time in incarceration. It is not designed to punish an offender based off of whatever offense they may or may have not committed.
But it does restrict their freedom and ability to move, and also monitors all their behavior, correct?
Not always, Your Honor. So this gets to another kind of issue that when we're talking about pleading, there are a panoply of conditions that can be imposed by the Commission. And the Commission alone gets to make those findings based upon, among other things, the conviction underlying it all, the defendants or the supervisee's conduct in prison. It's all up to the Commission to decide. So how intrusive it is entirely up to what the Commission and the defendants, and things that occur far after a plea is entered, much less a judgment. And so we get to this kind of question of, to stick with this kind of sentence discussion, being temporal in nature, occurring around the same time or even during a defendant's sentence does not make it a part of defendant's sentence. There are a number of things that occur during a defendant's sentence that I think we all agree is not punitive, that's not part of that sentence, where a defendant is specifically incarcerated, where a defendant is, or the custody classification a defendant may receive. those are decisions that, though maybe they are somewhat related to the conviction or where the conviction occurred, have no bearing upon this kind of discussion of criminal punishment and sentencing.
Let me ask you one thing about the procedural posture of the case. The defendant's Mar, when it went before Judge Albright, was summarily dismissed, correct?
Yes, Your Honor.
And the only time that a Mar can be summarily dismissed without a hearing is where there's solely legal issues, correct?
Well, not necessarily, Your Honor. Also, if there is insufficient facts that are pled, particularly under the Supreme Court's recent decision in Walker, which recently elucidated that principle.
Okay, but you agree that a defendant's guilty plea must be, quote, voluntarily, intentionally, and understandably made?
As a general principle of constitutional law, yes, Your Honor.
That's Bozeman.
That, yeah, certainly, Your Honor. It's traces
And Boykin versus Alabama.
Yeah, it certainly has a rich provenance.
So his understanding of the consequences, if we say that either PRS or registration is a direct consequence, would that not be a factual issue, particularly when the Mar is supported by affidavits of the defendant and his attorney, where they both say, we were not aware?
So the question of whether the attorney was aware would be a factual question, whether the attorney said to his client, the defendant in this matter, you do or do not, or you will be subject to registration and 60 months of PRS. But whether those consequences are direct or collateral is a legal discussion, one that this Court can and should conclude are collateral, because even if an attorney fails to advise his client of a collateral consequence, whether or not in actuality his attorney did or did not say those words is irrelevant for an IAC discussion. His attorney was under no obligation to inform him of collateral consequences.
Well, his affidavit avers that had he known, he would not have entered the plea.
Well, Your Honor, that's true, and that gets to a little bit of the prejudice discussion. But when we're talking about this deficient prong, there must be a showing that it is a direct consequence. That is a preliminary matter that the defendant fails to meet. Until we get there, any discussion about whether he actually said those words, whether the defendant actually understood it, whether the defendant would have accepted the plea or not accepted the plea, any of that, it becomes moot. It becomes an irrelevant discussion because the collateral consequences ends the inquiry full stop. The defendant cannot succeed in his arguments. And so I want to get to this, setting aside the kind of criminal punishment, too, of PRS. It is the legislature deemed it to be civil. It's deemed it to be, in its own writing under 1368A1, that its purpose is to recover, to integrate the defendant, to continue the prisoner's treatment or education, and to assist the prisoner into reintegrating into society. These are civil concerns. These are not punitive concerns. We can contrast that with the sentencing findings, which is to punish the offender. Those are two very different inquiries. Those are two very different legislative findings. And so to surmount those clear and express legislative wishes, defendant needs to show that the conditions of post-release or post-release generally is so invasive, is such a punitive measure that it overcomes that clear legislative finding, and he doesn't, particularly in this matter, where though, to be clear, it was 60 months of post-release supervision. He only served 10 of them before the commission revoked it and he was returned to prison. So he wasn't.
Do you agree that once the letter came, if he'd been brought back into court and say, okay, this is what's going to happen now, do you want to withdraw your plea or do you want to continue? Wouldn't that have been, I mean, we could have avoided every bit of this.
If he knew that there was, yes, certainly, Your Honor. If he had expressed knowledge of the registration and this PRS, certainly it would. We wouldn't be here. The discussion wouldn't be there.
And then for him to be summarily treated on his Mars and not have, I guess my concern is, you know, he agreed to plead guilty. He agreed to the sentence. He agreed to a period of post-release supervision. That's, quote, and then there were charges dismissed. I do see that on pages 7 and 8 of the record, and 9, where there were other charges dismissed and they were agreed to consolidate.
Yes, sir.
I mean, when you're making, quote, the deal, when you're doing the plea agreement, you're weighing, this is what I can do against facing the unknown. The problem here is that we had unknowns, more unknowns then in making that decision, do I go to trial, do I plead? That's my concern. And then once the error was discovered, he was not saying, okay, if you don't want to proceed on this plea, what do you want to do? Do you want to go to trial? It could avoid every bit of this.
So I think, Your Honor, though, so yes, to be clear, as a factual matter, yes, if the client or the court had said, hey, this is a registrable offense, which also means you're going to get 60 months, up to 60 months of post-release supervision.
And registration.
And registration.
30 years.
Certainly, Your Honor. Yes, we wouldn't be here as a factual matter, but that doesn't change given the kind of end result here, which is those are collateral matters. Those are.
And on the Mar, if he'd had a hearing and he said, I didn't know, and I wouldn't have done it. I mean, at that point, so what do you want to do? I mean, this could have been cleared up multiple times before it got here. And now we have all these motions and petitions in addition to this appeal to try to clean up something that could have been cleaned up at the beginning.
Certainly, Your Honor, if he was made aware of this, then yes, we wouldn't be here. And yes, this would obviate, or not obviate.
So there's a lesson here, isn't there?
Certainly, Your Honor. But I think still, even if that box was checked during the plea and no one said a word about it, and so thus there was no letter, there was no amended clerical correction, none of that, that would still bring us here if he wasn't aware of this. Though, to be clear, the state still maintains that these are collateral matters. Again, direct consequences have a lot of power because they allow inmates or individuals to undo pleas potentially decades later. There is no limit on when an MAR can be filed, so we must be careful about expanding that list. It must cut to the heart of the defendant's plea and his punishments. It must be clear, it must be definite, it must be automatic, it must be immediate. And so when we apply those principles to, for example, post-release supervision, it fails all of those matters. Though certainly 60 months is where post-release supervision starts, it is entirely contingent upon how the defendant acts. It is entirely dependent on how the commission interacts with the defendant. There are rehabilitative credit calculations that go into play. There is no indication about how long every inmate, much less this defendant, could face. Certainly 60 months is where it ends. But it could be shorter, could be significantly shorter. He could refuse to walk out of prison, and thus he would have zero post-release supervision and serve the remaining 9 months of his prison term. So when we apply that to the definition of direct consequences, it doesn't satisfy. And I think, too, when a good illustration is comparing it to a concrete prison sentence. There's no doubt that a concrete prison sentence is a part of a defendant's criminal punishment.
We're going back to the original crime and the fact that you have an attempted kidnapping and then a kidnapping. Mm-hmm. We know that restraint is inherent in any robbery. And basically, there's a long line of cases that if restraint is inherent in the crime itself, then that will not support a separate kidnapping conviction. And there's no evidence in the record, and the record's meager going back to the original facts. But there's no evidence that I've seen that there was any sexual assault on either of the minors. Basically, they were in there when the robbery occurred, and their freedom was restricted. One was attempted, one was alleged to be an actual kidnapping. But I guess the problem I'm having is why is that a sexual offense?
In short, Your Honor, it's not. Certainly there's no evidence to be a sexual offense. But I think this gets to registration generally, though it is, of course, colloquially talked about as sex offense registration. That's not the full purpose of the registration statute. Section 14-208.5 talks about the purpose of registration. And, of course, there is, first and foremost, a discussion about sex offenders and the need to protect them. But there is a separate paragraph within that policy concern that is certain individuals who commit certain crimes against minors are also considered to be a danger.
So if someone went into a school and robbed it, with or without a gun, and they locked the school down, would every minor in that school be kidnapped?
That would require a lot more facts, Your Honor. I'm not entirely sure. Potentially, I think.
Their movement would be restricted, wouldn't it?
Potentially. It would certainly be on the table for the district attorney's office to consider. But, of course, this gets to perhaps reinforces my point that certain offenses are sufficiently dangerous to minors into the community, such as going into a school and holding everyone hostage with whatever weapon he or she may or may not have. And this gets to the point of the registration statute, though it is, of course, colloquially referenced as sex offender registration, and I know my briefing did reference it as sex offender registration. It is a broader term than that. It is registration generally, and that's why when cases come up like this, where there is no allegation of lascivious conduct or improper sexual contact, it's still a registrable offense because it was committed against a minor. Those policy decisions were made by our General Assembly. They've been around for some time, and it's why he ended up where he is at now. And
You do agree that a sexual registration, he wouldn't have to be registered for the assault.
Sorry.
I mean, the robbery.
Oh, correct, Your Honor.
And he wouldn't have to register for kidnapping of someone over 18.
That's correct, Your Honor.
So the only fact is that triggered the 30-year registration is the fact that two of the people inside the premises were minors, right?
Is my understanding of the record, Your Honor, is correct in that we don't have a whole lot of information from the trial court about the specific factual basis or things like that. But I think that the indictment makes clear that it was a victim who was a minor, and that is sufficient to trigger the registration requirements contained within our statutes. And Judge Zachariano, it seemed like you were about to ask a question earlier. I don't want to.
Oh, I'm sorry. I think it's been answered. Thank you.
Okay. So getting to the registration generally, or I should say with PRS, I'm sorry. The other thing, too, that takes into account when we say about, okay, this is a direct consequence, that not only is able to undo pleas, but it places an affirmative obligation on defense counsel going forward to inform their clients of that. PRS is particularly troublesome in this regard because it is constantly subject to change. In the last decade, it has changed lengths, it has changed conditions, it has changed credit calculations, and every single time it has done that, it has had a start date of when, or all inmates who start post-release supervision on that date or later. And so there are easily those who could have been convicted. Maybe they understand that they're going to get 60 months of post-release supervision, but while they're serving their active prison sentence, before they start their post-release supervision, the legislature goes in and changes it. He would still have to play to that. So we're saying to a defense attorney that they have to sit down with their client, discuss the plea, and say, well, it is 60 months today, but that is subject to your conduct in prison, how the commission is interacting at that time, and also subject to legislative change that certainly I cannot predict. So when we say that it becomes an impossible burden for defense counsel, and when we're talking about the context of undoing 20-year-old pleas or nearly 20-year-old pleas, that only further reinforces that this is a collateral consequence.
Of course, you mentioned earlier that the defendant in this case agreed to PRS. You know, does that make a difference?
Well, I guess, so he certainly went on PRS for a period of time, I think about 10 months, and then it was revoked.
Did he agree to participate in PRS?
Well, so the way that the PRS scheme works generally is the prison will come to you and say, here is a kind of form, here's your conditions that you're going to have to comply with. In theory, he can refuse to sign it, and that's considered a violation of post-release supervision. And so as far as, yes, he signed that form. As far as I'm aware, of course, Judge Tyson, as you point out, this information is not in the record, but we do know from his affidavit that he did serve some period of time on PRS, roughly 10 months. So in terms of how it impacts the analysis, it just further reinforces the idea of kind of definite, immediate, largely automatic. We can compare and contrast it with a more traditional prison sentence. If a court says you will serve 15 to 30 months, there is nothing that the inmate can do, or the state can do, the executive branch can do, barring clemency, pardon, or any other extraordinary matter. He will serve 15 months minimum. He could be a model prisoner. He will serve 15 months. Or he could be the worst prisoner, and he would serve 30 months. Compare and contrast that with PRS, where maybe the conditions are entirely removed, and so he's basically operating with unsupervised ideas. And credits can come in, so we can lower that 5 years down to potentially even 0. There's nothing limiting at that time the commission to do that. And so it just doesn't kind of fall within the purview of something that the defense counsel must say to his or her client before pleading guilty.
Let me ask you this. Was the failure to register the only did he comply with his PRS except for the registration? Was it the registration that triggered all of this, the revocation, everything else?
I am unaware of the specific instances that triggered the revocation, and certainly it's not in the record. He did violate or failed to register, I think it was twice in the intervening decade or so, so that's certainly in the record. But
Other than that, though, you're not aware of any other conduct or criminal activity that would have triggered a revocation or a return under PRS, right?
I'm not certain about the specific violation of his conditions that caused the revocation. That's certainly outside the scope of review, and I'm happy to, again, kind of look into that.
So if the failure to register was the only consequence that brought him back in, and that limitation would have been over originally in 9 months, and it went out to 60 months, you don't feel like that would have made a difference to him on his decision?
So I think the difference there's a difference between whether it would have impacted his decision. I think everyone values pretty much everything differently. But the question is it direct?
Let me put it a different way. Do you agree that his conduct post the 9 months on the failure to register, that basically the consequence of that would not have been subject to the bring back? Is that correct?
So just to be clear, Your Honor, make sure I understand your question. You're asking me
if he was over and done 9 months post release, and he failed to register, he would still be subject to the registration and still be subject to criminal prosecution for that. Is that not correct?
Yes, Your Honor. Yes, he could be.
So if registration is collateral and the PRS is direct, I'm trying to understand the prejudice. If he'd been over at 9 months, but he still failed to register, and that is a collateral consequence, then are you arguing he cannot show prejudice as a result of that?
The state's position is that both consequences are collateral, but also there is a failure.
Well, let's presume
Certainly.
that the registration was collateral, but the PRS was direct.
So in that instance, Your Honor, we get to this kind of prejudice discussion, which defendant has not shown. Go forth, this court recognizes kind of two interlocking ideas. One of rejecting the plea, which he's certainly alleged he would do, but also have insisted on going to trial. And I think that's an important part here, because if we look through not only his MARs and affidavits, where he said he would have pled to some things, but not other things, and even counsel here today talking about how maybe we could have negotiated a better plea deal for more active sentence. That's not the test. The test is, would he have insisted on going to trial on those indictments? And that hasn't been.
And that is a factual, not a legal question.
Certainly it can be, but again, we're getting back to, has it been properly alleged for the purposes of under Walker, which in this case, it hasn't. There has been certainly allegations that he wished he could have gotten a better plea deal. And certainly, Your Honor, you point out, he says that it was an important discussion for him. And certainly for me, it would have probably been important consideration, at least the registration requirement. Certainly. But that's not the test. The test is, right, is it direct or collateral? If we say if it's collateral, full stop, inquiry's over, IAC denied. If it is direct, okay, then we can look at prejudice. Then we can say, well, did he insist that he would go to trial on this? Do he insist he would go to trial when we look at the record and see it's been almost 20 years since the original plea? It took him roughly 15 years to file his first MAR after serving several prison sentences for registration or failing to register. Would he say he would insist on going to trial when he got a somewhat favorable deal where issues were dismissed? The answer, Your Honors, must be no. And so
I'll give you a moment to sum up.
Respectfully, Your Honors, and thank you. At the end of the day, all of these issues, they were collateral in nature. A lot of them also have a number of procedural concerns. They also fail the prejudice prong. Whatever route you go down, we end up in the same place. The trial court did not err below. The MAR court did not err. And this court should therefore affirm.
Thank you.
Thank you, Your Honors.
Any questions? Question? Okay, thank you. Rebuttal? So I'm going to start with the first question. If the registration is collateral, the PRS is direct, there was error, how can you show prejudice if he had only had the 9 months, but was still subject to the registration and failed to register.
So if he had only had I guess if he's pleading to a registerable offense, he has the 60 months regardless, right? He made it through 9 months of PRS, but was revoked in the 10th month. So not knowing about that.
But the failure to register would have still been incumbent on him regardless of the period of the PRS. That's what I'm getting to.
Regardless of it.
Whether it was 9 months or 60 months, he still had a 30-year collateral requirement to register.
He did, but I think having your PRS revoked is different from a new charge, right? If you're having your PRS revoked, you're going back on that original charge and serving the rest of it in an inactive incarceration, and then also maybe on top of that, having the separate charge. I think that's the prejudice there. And happy to answer your questions, but just a few discussions about what Mr. Hayes was saying here. I will note that at the record, page 38 in Mr. Spry's affidavit at paragraph 9, he does specifically allege that he would have gone to trial on this. So in terms of whether the MAR on the affidavit specifically alleged what's necessary for prejudice, for a hearing on prejudice, I think that that's in your record. I would like to just touch briefly on what Mr. Hayes called a clerical error. I think it's a pretty significant finding, a checkbox on a judgment that's making a finding. Yes, the indictment certainly alleged that the kidnapping victims were minors, but we don't have any evidence in the record without a transcript, for example, or anything in the plea transcript, the written plea transcript, that suggests there was in fact evidence these people were minors, right? So you can imagine a case where the indictment alleges someone was a minor, you get to trial and she's like, actually I'm 18, the DA just thought I was 16, and that's not proven. We don't know that in this case, and that's another reason that it's both concerning that this happened outside of Mr. Spry's presence, and also that there's just not enough information about the facts in this case and why a hearing is necessary. And then talking a little bit briefly about why PRS is punishment. Again, Judge Zachary, you mentioned something about whether Mr. Spry elected to go on PRS. I would just point the court to section 15A 1368.2 subsection B. It says a prisoner shall not refuse post-release supervision. It's not a choice. You have to do it. It's automatic. It's direct. And then also talking about Mr. Hayes was talking about the burden on defense counsel about advising clients. Of course, we know that defense attorneys have to change with legislation all the time. Sentences change, maximums change, consequences change. I don't think that that's a reason to say that PRS is not part of the punishment. Mr. Hayes talked about how PRS can look differently and how sometimes it can be shortened, but of course that's the same as a prison term, right? Prisoners often earn credits on time and their sentence goes down. The same may be true for PRS, but I can say that the 60-month PRS that sex offenders are subject to is a form of punishment, and I think Mr. Hayes read you part of 15A 1368A1, but he didn't read the whole thing. One of the purposes of post-release supervision that he didn't mention was to monitor and control the prisoner in the community, which I think itself is the definition of punishment. I think this needs to be remanded for a hearing, and if you have no further questions, I'll stop there.
I have two questions. Is there anything in the record that explains the 15-year delay?
The 15-year delay on the MAR, yes. I think in Mr. Wells' affidavit, he talks about how he was appointed to Mr. Spry's petition for removal from the registry to help him with that. And it was only at that point that Mr. Wells, who's a barred attorney, told Mr. Spry that, look, this is a way that maybe you can get out of this plea, because he knew what Mr. Spry was concerned about. He knew what had happened. But Mr. Spry, as a layperson, didn't know that this was an option. This was a way that he may be able to get off the registry. He was doing it in the way that the paperwork that's given to all people on the registry told him to do it, to wait 10 years and to petition to get off the registry. But as we've discussed, he has these registry violations, and he's not going to get off that way, right? And so I think that explains the delay. And as you were talking about before, I think the other explanation for the delay is that Mr. Spry didn't know about these enhancements that were triggered by this kidnapping of a minor charge until shortly before his release in 2009. And then he just, even though it could have been taken care of, as you said, basically immediately at sentencing or brought back 2 weeks later when they got the clerk's letter. You're absolutely right. It could have and should have been done that way. But this is the way Mr. Spry learned to do it when he did. And Mr. Wells was appointed, I believe it says in the affidavit, in 2022, I think August, and Mr. Spry filed this in January of 2023, which I don't think is an unreasonable delay for a pro se litigant.
The other question I had, I wanted you to address the state's argument of waiver in that the PRS was not waived in the original MAR, but was raised in the supplemental MAR, which Judge Albright found was barred. You want to talk a little bit about that and why it would not be barred?
Sure. I honestly can't remember if I've already pointed you these paragraphs, but I would just point the court to record page 34 in the MAR, paragraph 12, record page 36, paragraph 12A, which is a wholly handwritten paragraph, and then also record page 38, which is Mr. Spry's affidavit. In each of those, he raises this PRS claim.
And these were attached to the original MAR, not
That's
the
right.
supplemental.
That's right.
But what was the purpose of the supplemental then?
Honestly, I think that it's called supplemental in the briefing because that's what Judge Albright called it. I think it was a motion to it's titled a motion to reconsider and amend. I think it's his pro se attempt to say you missed something, and I do think it talks about it more. But I also think under this court's decision in Hyman, which the Supreme Court adopted, we don't demand perfection from pro se litigants, right? He put this claim, he cited Blakely and a School of Government blog post that isn't exactly on point, but I think that the claim is squarely presented if you look at it. So in paragraph 12 on record page 34, he says, "It is my belief that these registrable kidnapping-related convictions resulted in my receiving 5 years of post-release supervision. This time period is different than persons convicted of crime that do not carry sex registration." He cites the statute, 15A 1368.2. "This additional post-release supervision was never explained to me prior to my 2007 plea, and I have never attended a court hearing where I had notice and a chance to address this question in a courtroom." And then he does it again in handwriting. He talks about how he thought it was going to be 9 months. That's at paragraph 12A of record page 36. And then in his affidavit again, he says, "This additional post-release was never explained to me as part of my plea." I think that under Hyman, that's, which is it's a case where the defendant was saying that he's going to make this claim in assignment of error 10, and then it never appeared in assignment of error 10, but there was an allegation of the attorney's conflict in a paragraph that was outside of assignment of error 10, and this court and the Supreme Court both said that that was sufficient to preserve a pro se litigant's IAC claim. I think under that, the claim was squarely presented in the MAR. I know Judge Albright didn't address it, but it is there. Yes, there may have been more in the amendment or supplemental MAR, whatever we want to call it, but it's there, it's sufficient in that first MAR.
Let me ask you this as far as, and I know that you want us to vacate the guilty plea. Are you arguing there is a factual determination of where he knew or not that was not addressed by Judge Albright? Is that part of your argument as well?
I do think that there's sufficient information in the affidavits, but to the extent the state is contesting anything in the affidavits, I think it is a factual question that needs to be determined, yes.
So we don't find facts here.
Right.
So would an alternative disposition be to remand it for evidentiary hearing on the MAR?
Yes, I think that's wholly appropriate.
Okay, anything
Thank
else?
you. No.
Would you have any questions? Thank you. Thank you. The case is submitted. We appreciate the good arguments, and if you want to submit additional memorandums on the two issues that I raised, the court will be glad to receive it. You're certainly under no obligation to do that, but if you feel it would be helpful for the court, we would be open to that. Okay? Madam Clerk, you adjourn the court?